Hello, everyone. This is Louis. Welcome to the channel. If this is your first time here, well, thank you for dropping by. The purpose of this channel is to share some good and useful information with you, and hopefully, this will give you some positive energy to enjoy your day. Now, today we're going to continue our discussion on estate planning. This is the second part of the Estate Planning Made Easy video. Yes, I understand it is very emotionally challenging to talk about death. And that's why most people will find all sorts of excuses not to talk about it. But what they don't understand is a well-documented estate plan could help them to pass along their remaining assets or possession to someone that they want. This could even be their other family members, charity, or even their pets. However, an estate planning mistake could destroy a well-intention of looking after their loved ones. So today we are going to take a look what kind of mistakes people make to their estate plan, and hopefully you will not make the same mistakes. Now, most people believe sudden death will never come to them until they suffer a medical emergency. I certainly had experienced the anxiety of not having a current will when the doctor told me that I may not have too many days left in 1997. At that time, I was young, with a young family and a good career. I never thought this could happen to me. Well, thank goodness, the doctor was wrong. I am still here today. The reason I'm telling you this story is I want you to understand estate planning is not just for the seniors, it is for everyone. A high percentage of Canadians have no wills or an updated will. It is because they think the wills are just for the rich and the elderly. An out-of-date will actually may cause more confusion and may even delay the settlement of the estate. It is important to update your will whenever circumstances change in your life. The most common circumstances, such as marriage or divorce, the birth of a child or grandchild, or a beneficiary has passed away. You also need to include any new assets or debts that you have acquired. Just remember, by delaying or ignoring, you are putting your loved ones at risk and can even cause ugly disputes between the children. When an unexpected death occurs, often the surviving spouse or the beneficiaries have no idea what and where are the investments, bank accounts, and their current valuations. And that is why the banks and the insurance companies have many unclaimed accounts and policies. So make sure let your spouse or beneficiaries knows where are all the investments, bank accounts, and their current valuation. Now, to avoid disputes between children in the future, it is important to name the beneficiaries and their share of the assets. You may also need to name a trustee to take care of the funds for a minor child or a disabled child. Often, it is difficult to decide how to distribute your estate. Just remember, equal does not always mean fair, and fair may not be equal. If you have made a special bequest to a child, make sure you state the reason for such an allocation. And if you have a joint account or a joint ownership of asset with a child, then make sure you state whether it is a gift for that child or is it a trust for your estate in the will. Basically, there are two types of beneficiary designations, per capita or per stirpes. The default beneficiary designation among all financial institutions is per capita, and that means each child is simply as co-beneficiaries. Then upon your passing, each predeceased co-beneficiary is just eliminated from the inheritance, and the portion will be proportionally divided between the surviving co-beneficiaries. Now, the premature death of a beneficiary could cause the children of the deceased beneficiary to be unintentionally disinherited. On the other hand, the per stirpes designation distributes the portions to each branch. That means the share that would have been given to the deceased beneficiary is distributed equally among the deceased beneficiary's children. Also, make sure all the people that need to be looked after are properly recognized. In the case of a divorced couple, Quite often, the ex-spouse remain as beneficiaries, causing the current spouse to be denied of benefit. Now, if the estate is complicated, consider using life insurance trusts to avoid any confusion. However, this topic is beyond the scope of this video, but make sure you discuss this with your estate lawyer. Assets liquidity is important. You need to consider what needs to be done with some of the illiquid assets, such as rental properties, cottages, or any assets that cannot be liquidated within a short time frame. Make sure the estate has enough liquidity to pay taxes that are due. Naming the right executor is important. The person should be someone that you can trust. Most people name their spouse or children as the executor of their will. Now, this may not be a good choice, especially when the spouse or the children have no legal knowledge or the time. You also need to name a contingent executor just in case the appointed executor may not be able or willing to take on the task. You can also name a co-executor, such as a bank or trust company, to assist the primary executor. You may not want to appoint your children as joint and several executors. This may cause conflict among them. The best idea would be to choose one that you believe can have the time and the knowledge, and most importantly, the respect from other children to take on the task. In addition to the will, you also need the enduring power of attorney, should you become mentally or physically incapable of deciding for yourself. Now, there are two types of continuing power of attorney, one for the property and the other is for the personal care. In my last video, I also mentioned that you should instruct your power of attorney and the doctors whether to use or not to use life support. Further, you may also want to address the medical assist suicide issue as well. Now, you can cancel the attorney's appointment at any time. In addition to the will, you also need to gather some of the documents for your executor, such as your passport, social insurance card, marriage or divorce certificate, and any prenuptial agreements. You also need the deeds for any properties that you own and loan documents as well. Now, you need to understand when you have no will or no executor, your estate will be settled by the province intestacy law, or someone will have to apply to the court to handle your estate. Yes, writing up an online will is possible, but I don't recommend it. A lawyer can help with some of the complex financial matters or complicated family situations. After you sign your will, do not keep it in a safety deposit box at the bank. Just keep the original will in a fireproof safe and in a secure location. Make sure your executor knows where it is. Well, that's all for today. I hope you find the information useful, and if you enjoyed the video, please give us a thumbs up and subscribe. Until the next time, please take good care of yourself and enjoy each day to the fullest. I look forward to seeing you again soon. Goodbye.